The national debate on guns and gun laws continues in the wake, obviously, of last week's shooting in Oregon. Now, 9 people, as you know, were killed. That when a gunman opened fire inside an Oregon college. And we're learning much more about the gunman. He was 25 years of age, 26, excuse me, and apparently had a history of mental illness, perhaps even Asperger's. But his mother apparently encouraged his love of guns and even purchased some of the weapons used in the shooting. And then there's a stunning story that came out of Tennessee. A little bit less of national publicity, but nonetheless, it adds to the national narrative on some of the insanity surrounding the subject. An 11-year-old boy asked an 8-year-old girl if he could play with the puppy that she was holding. The girl said no. So the boy decided to go back into the trailer home that he was calling her out of, grabbed his father's shotgun, loaded, and left available for the teen, or the child, I should say, to get a hold of. He then went to the window and shot and killed a little girl, shooting her in the chest with said shotgun. 11-year-old has been charged with delinquency by first-degree murder in what investigators have deemed an intentional shooting. We have not read any reports or any charges as of yet as to whether or not the boy's father, who owned the shotgun, has any exposure in this. Doug, I've always, this is a complicated subject that you can't solve or fix in 5 minutes. I will say this will be a political subject, I think, for the first time in an election, at least on a national level, in the coming year. But that said, take this case in isolation. And we've had elements of it in the Lanza case where clearly a disturbed person was provided guns by his family, and then you can argue it wasn't completely unforeseeable what would follow. This 11-year-old boy was allowed to be in an environment where a loaded shotgun was available to him. I don't think the father thought for a minute that the kid would go shoot an 8-year-old girl, but nonetheless, the parents of that 8-year-old girl will never be able to see her again. And more than punishing the 11-year-old, is there any criminal availability, not civilly here, but criminal availability to go to the parent and say, negligence, recklessness, whatever you're going to tell me the right legal term for it is, was his actions because he didn't secure a firearm in the presence of a child?
I would say yes. So you have to separate it into civil and criminal, as we always do. And if you're looking at this clearly civil liability in a case like this, but if you're looking at the criminal liability, it has to be more than negligence. It's recklessness. And if you're looking at reckless endangerment in a case like this...
What's the distinction between negligence and recklessness?
Well, recklessness would be a higher standard. So negligence, if you think of the standard, more likely than not, that would be the civil standard. Beyond a reasonable doubt is the criminal standard. It has to be more than just negligence. It has to be recklessness. And the recklessness would basically take the place of intentional conduct.
To be reckless, do you have to prove that in this case the father, whatever the parent, but in this case the father, it was foreseeable that if he left this out that there could be a tragedy?
Well, the recklessness is really in his conduct. If you take a loaded weapon and you leave it out where an 11-year-old has access to it, that would be the reckless conduct. If you had the gun put away and the child breaks into it somehow, now it's less reckless, and maybe it now slides into the civil realm of negligence.
Yeah, but you have to understand that in the second case, this is core Second Amendment as currently interpreted by the Supreme Court. This is having a gun in your house for the protection of house and home. Core constitutionally protected activity. Now, I'm not an expert enough on Second Amendment doctrine or firearm doctrine to know how the firearm has to be stored in the house. At a minimum...
Does it make a difference who's in the house, though, Mark?
I don't think it
makes... If he lives by himself, that's one thing, but if you have a kid, doesn't it make a difference?
That may well be a matter of local registration, but at a minimum, the firearm can't be stored in such a way that it would inhibit the protection of the home from an intruder. But it seems to me that a lock on the fire, and I'm not saying I agree with this interpretation, but that's Second Amendment doctrine. A lock on the firearm, though, would not appreciably jeopardize the safety of the house and home from an intruder.
Just a little background. There is no federal law. It's really state laws. So there's really two things you're looking at as far as the criminal. You're looking at the access to the weapon. There's state laws about access to weapon, who gets access to it.
Right, but they have to pass Second
Yeah,
Amendment muster.
and the second one is the delinquency of a minor. If you're what you're doing, are you basically? And they came out of
Contributing to it,
California,
right.
And there was a lot of gang activities, and they said to the parents, "Listen, you're responsible for this criminal behavior of your kids." So you have to look at it in two ways. And you're right, until it's tested constitutionally.
But the first case, he's putting the gun in the hand of the child. There's no Second Amendment protection for that. That's a much more clear-cut
recklessness is being aware of a risk. I mean, in its most simplest terms, being aware of a risk and disregarding it. So if you've got a loaded weapon on your table and your child is running around and you're in a home where you're basically saying weapons are great, you know, you get back at people for them, that you use them for certain purposes, you've got an 11-year-old child interpreting those words. When you leave that loaded weapon on your table and you've raised your child that way, are you not aware of the risk that he is going to put it in his hand and shoot somebody?
I understand,
But
but
a lot of it is going to be determined by the facts of this
that
particular
is
case.
exactly right.
So you may have an 11-year-old who goes hunting with his father all the time and actually loads and cleans the rifle, never had an issue. Nobody would have ever thought that this kid was going to hurt anybody. So at that point, it doesn't put the father in a position of being reckless.
Does that matter though, Mayor? Because you can't, if you create an environment where it's available, even if the person's familiar, in this case, with a gun and everything else, the environment that presented itself is foreseeable. Kids are going to have arguments. People are going to have crosswords. The kid obviously doesn't have at age 11 the cognitive ability of an adult. So if you leave something around, whether or not the kid knows how to hunt or not doesn't change the fact that he can't reason theoretically as well as an 18 or a 21-year-old.
But the other argument would be that the same outcome could have occurred with kitchen utensils. You could have used a knife and grabbed a butcher knife out of the kitchen and gone and run out and done the same thing. So you do have to look at it and determine specifically what is this child's background. Does this kid have a history working with firearms? It's very different from the case we dealt with when the girl was shooting, I think it was the AK-47 and shot the instructor and killed him.
In Arizona,
That's a very AR-15, I think. It was a very different situation. Here, I think, to Doug and to Jim's point, if you can show that a parent or another adult subjects a minor to injury to their mental, moral, or physical well-being, then you can charge them with endangering the welfare of a minor.
not if
you
it's
can
constitutionally protected conduct.
Well, no, you
Is
still
every
can, and if
constitutionally
you
protected right
doesn't
absolute?
mean
No, it's not absolute.
No.
There's going
I'm
to be
sorry, Mayor.
restrictions on how he can store the firearm, and I'm sure when he got the license, you know, he had to pass certifications
Maybe.
and represent how the firearm would be stored. But you know, we don't
Maybe.
even know what happened.
No,
Maybe
I'm not
there
saying
was
we
a
do.
shooter
Fair
in the
enough.
house
But-
5 minutes
But for
beforehand.
me,
and the gun was
as a
left out.
non-attorney at the table, I remember one of the things that had an impact in the amount of drunk driving. Sure, there was an effective campaign by MAD, but when bars all of a sudden knew, and you guys, a lot of you guys worked in DA's offices, if you were a bartender and you continue to overserve somebody who was clearly drunk, they got in the car and they went after, you had some exposure, civilly and
I
maybe even
understand. It's the
criminally.
dram shop,
And
yeah.
magically, all of a sudden bars started looking at who they were pushing the fifth and sixth shot to. And they thought second
but that's
about it.
commercial activity. The home is on a different, and I'm not saying I
I
agree with
understand, but for me, I think one way to approach this on a broader level is if people, whether it be gun manufacturers, gun distributors, who right now have blanket immunity as a special exemption that no other industry does, but guns manufacturers do in this country thanks to Congress, if all of a sudden people have skin in the game on the actions of people who buy their firearms, who then, when purchased, where you leave your firearms, if there is responsibility attached, I'd like to think
but this
that
is too
some people are going to treat
This is too
something
attenuated
that
from
can
the
cause
seller.
life and death more differently because they have exposure.
Technology may end up being the answer here because
true.
just as with your phone where your thumbprint can allow you to open that phone and
But
unlock
you know,
it.
and I know, Mayo, even that they consider a slippery slope.
Well,
Trigger locks,
except
smart guns,
there
everybody.
is the technology
there's
where the
ignition
gun
locks,
will
though.
be recognized by the owner. So only the owner will be able to use that
Yeah,
particular
biometrics.
handgun.
Yeah.
You know,
And that prevents kids
straw
from using
sales
guns.
too.
Yeah, but
theoretically would
that
help.
could be a Second Amendment problem. Suppose the non-owner wants to get at the gun
Yeah.
to
And
that person
protect
get a
the
license
intruder.
to
To your point, Rich, though, you said, you know, it changes the system. People have skin in the game. You got to be very careful when you think like that. The legal system is not there to legislate. The DA has to make very important, strong decisions about who to prosecute and why. And it's not their job to prosecute somebody just so that they change the conduct of people generally.
You're right. But if it was our 8-year-old daughter who didn't come home that night, and I know you can't do law that way, right?
can't do it
I
that
know
way,
you
Rich.
can't. But if you're the parent and you say, I can't get my kid back here because somebody didn't exercise the slightest scintilla of judgment,
You start
that
a
we come
movement.
back to the Second Amendment here as a rationale for that.
It's not that. The
I'm
Second
sorry, if the
Amendment is
kid
not
all
a
of a sudden-
rationale for giving a mentally disturbed child with Asperger's disease a gun.
Yeah.
That's a different issue.
But
That
that's
is a
a
different-
different. That's
Yep.
the
And
test
You
case right
start a
there.
movement
That's
to try
the
to
test
change
case
the
right there.
legislation. I mean, that's what needs to happen.
And
because
now we got to
Doug
get
is
back
right.
to the
That's right.
legislatures instead of the courts. Okay.
No, I don't think you need a legislator to prosecute the first case. I mean, that is beyond recklessness. That's putting the match in the arsonist's hand.
Unfortunately, she herself had Asperger's reportedly, so where that goes, who knows?
Well, what
okay.
about the Connecticut case? I mean, she didn't have Asperger's.
Yeah, if she wasn't killed, I think that I would like to think, at least in the Lancer case, there would have been some exposure for the mother. All right, we are asking the same question I asked this table to you at home tonight here. Should parents be held responsible when their children commit gun crimes? I'm talking about minors here. Head over to our Facebook
she get a
page
gun
or
if she
Fun
has Asperger's?
on Twitter, and please sound off.
Seriously.
Coming up next, the sheriff of Albany, Preet Bharara, of course, is playing defense. That after a smackdown from the Supreme Court, and also playing offense as he expands his Albany investigations.